Good morning, everyone. Welcome to the first webinar of our Intellectual Property series in collaboration with the U.S. Patent and Trademark Office. Today's webinar is Intellectual Property 101. My name is Valentina Pirazzi. I am the Director of the Innovation and Technology Center of the Puerto Rico Small Business and Technology Development Centers, better known as PRSBTDC. The PRSBTDC is an agreement between the Inter-American University of Puerto Rico and the Small Business Administration, or SBA. The purpose of this agreement is to offer business advice and technical assistance to small and medium enterprises. This webinar is being recorded for educational purposes only. Our speaker for today is Ms. Elizabeth Dorothy, Eastern Regional Outreach Director for the U.S. Patent and Trademark Office, or USPTO. Ms. Dorothy carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and Director of the USPTO, and is responsible for leading the USPTO East Coast stakeholder engagement. Ms. Dorothy ensures the USPTO initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. Welcome to the webinar.
Good morning, Valentina, and thank you for that warm welcome. It's a pleasure to be here with you, and it's a pleasure to kick off this multi-part series on intellectual property. Today is the first in 7 parts where the U.S. Patent and Trademark Office is going to collaborate with the Puerto Rico Small Business Technology Development Center. And that's our pleasure to do so, to bring together and to share information and education about the role and importance of intellectual property. Today on the call, on our webinar, I have a colleague with me, Edgar Guerrero Erazo, and Edgar is a patent examiner working in the area of speech recognition, natural language processing, examining patent applications in things such as Siri and Google Home, so things that we've all come to know and love. And Edgar is going to assist in our presentation today. He's going to tag team teach with me. So thank you to my colleague Edgar for being on. And with that, I'm excited to start our conversation. So as Valentina said, my name is Elizabeth Doherty. I serve as the Eastern Regional Outreach Director, which is really just a long way of saying that my team and I work with the stakeholders of the East Coast, the 17 states from Maine to Florida, and including the District of Columbia and Puerto Rico. It's our pleasure to work with you to, again, provide education and information about the role and importance of intellectual property. I'm a 30-year veteran of the office, having started my career as a patent examiner like Edgar, but it's my pleasure now to get to interact with inventors, innovators, and entrepreneurs every day of the week, making sure they have the resources and knowledge to bring their technologies forward. With that, I'm going to jump directly into our slides. And again, we welcome your questions through the chat, and we're going to get to all of those at the end of our conversation today. So here we go. So today, what are we going to talk about? We're going to talk about Intellectual Property 101, but starting with the conversation of why IP is a business strategy. Why is intellectual property important, and why should you, as someone who is considering or in fact starting building and growing a business? What is intellectual property? What is the U.S. Patent and Trademark Office? And what are those 4 basic forms of intellectual property? We're going to talk about trade secrets, copyrights, trademarks, and patents. Throughout the rest of the series, we're going to do a deeper dive on much of this content. So today is really an introduction, and it's a chance to get your feet wet with the concept of intellectual property. So let's look at it from a 30,000-foot level. Let's look at it from above our nation in a global capacity. Why is intellectual property important? Intellectual property is important because IP-intensive industries are part of our economy. They, in fact, create jobs, 45.5 million jobs, in fact, and these jobs are jobs which produce higher pay. So those companies, those industries, which are built upon intellectual property portfolios, again, whether that's patents, trademarks, copyrights, or trade secrets, they are producing jobs, and they are producing wealth and input into our economy. 38.2% of the US GDP comes from IP-intensive industries. Don't you want to be a part of that? Taking it down a notch, taking it down to a more personal, individual level, as a business owner or someone considering starting a business, Why is an IP strategy important, and why is it a business strategy? Because for starters, it is attractive to investors and buyers. For any of us who have ever seen Shark Tank, the show, what is one of those first questions the sharks always ask? They always ask that person who's pitching their product, do you have a patent? Do you have a trademark? What does your intellectual property portfolio look like? By having intellectual property and by alerting the public to your possession of intellectual property and that it is protected, you can deter infringement lawsuits. You can alert people that you have a patent or a trademark, a copyright, not so much a trade secret, because again, as we'll talk about, that's a secret. But by putting people on notice that you have a patent, trademark, or copyright, you can indicate to them that if they copy your work, that they are doing it at their own risk and that you could in fact go after them. It increases your leveraging power. This goes back to being attractive to investors and buyers. By having that intellectual property portfolio, you are building value into your business, which can add to your bottom line. It's a property right that adds to a company's assets, again, because it is something like real property that can be bought, it can be sold, it can be licensed, it can be given away. It's also global. So IP strategy is global. What does that mean? Well, for most of us who are working and producing a commercial product or investing in a business, in all likelihood, we are doing something in a global environment. We're putting our product out there on the internet for people to buy. Now, with that said, I do want to have the concept, and we'll talk about it again further in our slides. Intellectual property is territorial, and the rights that are given are based upon the country that issues those rights. But we'll talk a little bit more about that in an upcoming slide. So when we say IP strategy is global, it's because your business strategy in all likelihood is global. So you want to have a global perspective with respect to protecting your intellectual property. So why does invention matter to you? And this is going specifically to the conversation about patents, is that it can promote innovation and help safeguard your inventions. Again, remember, by having a patent, by labeling your invention with its patent number, you can let people know that you have a patent in place and you are seeking to protect it and that people should not copy your product. It helps companies grow. Companies that build an intellectual property portfolio and specifically a list of patents, they are continuing to advance by growing and diversifying their technologies or building upon foundational technologies. Patents also help benefit the community by making new goods and services available. By offering new products, by offering new things, new problem solvers, we are helping make people's lives better, healthier, more fun, more enjoyable. And of course, having patents can provide personal and I would say professional growth as well, development and advancement. I'll give you a simple example. My father has a patent. Now, that invention was never commercialized, but my father's always been incredibly proud of his patent. His patent still hangs on his wall, and I know he is proud to be considered an inventor. So let's take a step back and actually address the question of what is intellectual property. In our image here, we see a house indicating real property, and we see the Thomas Edison light bulb, intellectual property. Well, real property, as juxtaposed against intellectual property, real property is that tangible property that you can buy, sell, lease, give away, dedicate to your heirs. It's things like a house, a car, a boat. And think about when purchasing or transferring real property, you're going to sign on the dotted line. There's a lot of complexities in real property ownership, and that's no different in intellectual property. Intellectual property, as distinguished from real property, is property of the mind. As the name suggests, intellectual property. It is creative property created by the mind of an individual or an organization or a team or a business that has worked together to create a solution, to identify some aspect of a business or an endeavor that has been produced through some type of creative process. So intellectual property, very simply, is property of the mind. And like real property, can be bought, sold, licensed, given away. So next, and most interesting for my team and I, Edgar and I, What is the U.S. Patent and Trademark Office? Well, we're the folks that are here with you on the call today, and we are America's innovation agency. We are, in fact, the government agency that issues U.S. patents and that federally registers U.S. trademarks. We are a 13,000 person agency headquartered in Alexandria, Virginia, though we have regional offices in Detroit, Denver, Dallas, and San Jose. Now, like many of you today, we are all still teleworking due to this horrific pandemic, but we hope to be back in our offices soon. When we break down the U.S. Patent and Trademark Office even a little further, we are comprised of approximately 8,000 engineers and scientists who serve as patent examiners, like my colleague Edgar, doing the work of examining U.S. patent applications every day of the week. Now, to that, let me just share with you that each year we receive over 600,000 U.S. patent applications, and those come from both U.S. citizens and foreign citizens. You do not have to be a U.S. citizen to apply for a U.S. patent. And in fact, that's one of the beauties of the U.S. intellectual property system. No one is too old, no one is too young. We welcome all diversity of inventors and innovators to apply for a U.S. patent. We are part of the Department of Commerce, and again, our headquarters is located in Alexandria, Virginia, and the photo here on the right is just a quick snapshot view of our office. We are perhaps the oldest, if not the oldest, government agency, and our work is actually found in the U.S. Constitution. As I said, we're the USPTO is America's innovation agency, and that means that we are committed to assisting our nation in fostering innovation and economic growth and creating a reliable, predictable, and high-quality IP system. That's why conversations like what we're having today are so incredibly valuable, because we do want to encourage and incentivize each and every individual to see themselves as an inventor, innovator, entrepreneur, and to participate in the innovation economy and to participate in intellectual property. This slide just actually covers some of the things that you and I just spoke about, the breadth of the USPTO, so we'll move right on. As I said, we are perhaps the oldest government agency, our work actually being in the US Constitution. The founding fathers of our country saw and were able to identify that in order for us to be a strong and industrialized nation, we would need to protect the writings and discoveries of inventors and authors for a limited period of time. And with that, the first patent laws issued in 1790, and in fact, we issued the first US patent in 1790. This year, I'll let you in on a little secret, we will issue patent number 11 million. We anticipate maybe sometime in June, but certainly this summer, we will hit patent number 11 million. Now, you may say to me, Elizabeth, you said that we started issuing patents in 1790. From your chart here, it appears that the first patent issued in 1836. Well, strangely enough, from 1790 to 1836, we did not number patents. So in fact, when we issue patent number 11 million, we will have already issued over 11 million patents, because between the years of 1790 and 1836, we issued approximately 10,000 patents, but those patents were not numbered. They're now known as the X patents, 1X, 2X, 3X. So again, in fact, when we issue patent number 11 million, we'll be issuing close to patent number 11 million, 10,000. So the types of intellectual property we're going to talk about today in this 101, in this introduction to intellectual property, are patents, trademarks, copyrights, and trade secrets. What I want you to take away from our conversation today is that there are 4 different types of intellectual property protection at a very basic level. I want you to also take away that they protect very different things and that they are good for different terms. So again, let's remember and let's take away from today's conversation that there are 4 basic types of intellectual property: patents, trademarks, copyrights, trade secrets. They protect very different things and they are good for very different periods of time. We're going to speak about all of these today, but as our name suggests, the U.S. Patent and Trademark Office issues U.S. patents and federally registers U.S. trademarks. Copyrights are handled by the U.S. Copyright Office, which is a part of the Library of Congress, And trade secrets are handled under the Uniform Trade Secret Act and are oftentimes found in contract law, particularly between an employer and an employee. So let's move into talking about these various forms of intellectual property. Before we do so, here's just another chart that lays out again what each of these types of intellectual property protects, examples of some of the things they protect, and a duration of that protection. And this is important because frequently when talking with individuals who are just beginning to appreciate intellectual property, you can see the confusion. I've had people say to me, well, Elizabeth, can I get a patent on my trademark? Can I trademark my copyright? Can I get a copyright on my trademark? So there's a bit of confusion. So we want to make sure that everyone is clear of how this is happening. So I see from my colleague that the slides are not advancing. Are you not seeing the slides? Is there a problem?
Yeah, it seems to be from the slide 1. We're about on slide 12 at this time, but it's not advancing.
Okay.
Tried to troubleshoot it, but it doesn't seem to be working on the other side. I don't know if the...
So what slide are you all seeing, unfortunately?
We're only seeing slide 1 up to, but it's not in presentation mode, but it is.
Okay.
The rest of the slides are in there in the default section, but we're not able to advance the slides.
Is it
Elizabeth?
Yes.
Sorry for this. They're taking care of it to see
Okay.
what's going on. So hopefully this technical glitch in a few seconds will be corrected and
Okay.
we can go on with the presentation.
Okay. Would you like me to hold for the moment?
Do you think that, well, yes, please just, if you can just go on.
Okay. All right. So,
yeah. I'm sorry. I was going to say, is there a way how to manually advance it? Or is it in some sort of automatic presentation mode?
So I am advancing these.
Yes, but oh, there we go. Now it's working. We're
Okay.
on slide 12. Yes.
Okay, fantastic. So now we are seeing the slides?
Yes. Yes.
Okay,
Yes.
fantastic. Oh, I'm so glad. So I'm not sure why those paused. Do you want me to go back to any of those previous slides or just continue from here?
I think we can continue from there. If there's any question, we can go back.
Certainly.
Thank you.
Certainly. So hopefully now, my apologies for that glitch. We are seeing the overview of intellectual property, and you are seeing a chart that displays the different types of intellectual property protection, what they protect, examples of things that are protected, and the duration of that protection. Now, you may say to yourself, now, Elizabeth, you mentioned earlier that there were 4 types of intellectual property: patents, trademarks, copyrights, and trade secrets. However, in this chart, you're seeing more than that. You're seeing 6 types. Well, what we've done in this particular chart is to break down the types of patents. There are, in fact, 3 types of patents: utility patents, design patents, and plant patents, each of which protect a very different thing. So if you notice with our utility patent, and that's the patent we think of that covers inventions. Now that's certainly one way of looking at it, but our other patents also cover inventions. But the utility patents cover what we think of as a new bicycle, a new cellular communication device, a new complex database. They protect your invention for 20 years from the date of filing your patent application in the US. Design patents protect that ornamental appearance of an article of manufacture and are oftentimes part of the same portfolio with a utility patent. So think about your cellular communication device. Think about your phone, your cell phone. It is probably covered and probably contains within it numerous patents for the various elements of that phone, but it is probably in all likelihood also covered by a design patent, which protects the appearance of that phone. Plant patents protect any newly invented strains of asexually reproduced flowering plants, fruit trees, and hybrid plants. Think about rose bushes, think about poinsettias, think about fruit trees. Nearly all of them are protected by a plant patent. Copyrights have an incredible duration, the life of the author plus 70 years, and cover a wide range of things, which you'll see in our discussion. And then, of course, trade secrets, anything that brings value to a business that can be kept secret. Let's talk first about trade secrets. So when we think of trade secrets, again, it's anything which can bring value to a business which can be kept secret. Perhaps two of our most famous trade secrets, or most recognized trade secrets in common terminology, are the recipe for KFC chicken. What makes that chicken so good? What are those ingredients and spices that the Colonel puts together? And then, of course, the Google search algorithm. How is it when you type in search terms, Google is able to return to you results that are pertinent to the search that you're seeking? It is their Google search algorithm, which is maintained as a trade secret. So what's important to know about a trade secret? Well, for starters, how you can lose a trade secret. Because again, a trade secret is an incredibly important form of intellectual property because it can last forever if you can maintain it as a secret. So you have to prevent losing your trade secret. You have to prevent others knowing of that information. So you can lose a trade secret by failure to take adequate steps. As I mentioned, oftentimes trade secrets are within a business and protected by employment law. Your business owner, your boss says to you, the employee, in that employment contract that you've signed, that you are precluded from sharing this information with others. And in fact, some businesses, and they say this is true of the recipe for Coca-Cola, anecdotally, I don't know if it's true or not, but they say that no one employee has all of the recipe ingredients for the secret of Coca-Cola. That's one way that they have ensured that it is maintained as a secret. So if one employee were to tell what they know, that doesn't give away the recipe. There can also be owner or owner authorized disclosure, and this happens. Maybe you determine that it's time to share that information, or it's done knowingly or not knowingly. Reverse engineering and independent development, these kind of go hand in hand. And this is where if you are creating an invention, you need to think twice about, once you have that invention and you start to commercialize it and it's out there, can people reverse engineer what your invention is, or could somebody independently develop it even without having access to your invention? If so, then perhaps your invention is not one that should be protected by a trade secret. If others can reverse engineer it or perhaps independently develop it, then you might want to seek using some other form of intellectual property, namely a patent. So let's talk copyrights. As I said, copyrights are protected by the Library of Congress, and they protect original works of authorship. And they can be many different things. They can be literary works, dramatic works, musical, artistic, and other intellectual works. Now, one of the interesting things about copyrights is that copyrights are what we call self-authenticating. Merely by taking that original work of authorship and placing it in a fixed medium, you are in fact creating a work that is protected by copyright. Now, to avail yourself of additional protections, it's encouraged that you register that work with the U.S. Copyright Office, and it's a relatively simple online process. But you have, in fact, obtained a copyright by placing that original work of authorship in a fixed, tangible medium. So for any of you who have ever written a paper, you have written a letter, you have written a poem, you have written a song, and you've written it down on your computer. You've written it down on a piece of paper. You, in fact, are the owner of a copyright. And I would argue that each one of us in this audience today has many, many copyrights. Now, whether you've registered them with the Library of Congress is another issue. As I said, copyrights have an extensive life, the author's life, the producer, the individual, the creative individual who created that original work of authorship. The copyright lasts for the term of their life plus 70 years so that their heirs can benefit from that creative work. Here's some great examples of things protected by copyrights: songs, movies, books, sculptures. So to this point, to be protected by a copyright, there has to be a certain level of creativity involved. And you may be thinking to yourself, what does that mean? Well, I said if you take something and you place it into, you author something and place it into a tangible fixed medium, you have a copyrighted work. Well, I write a grocery list because I'm going to go to the grocery store later today. Is that a copyrightable work? Probably not. Is there any inherent creativity in just writing down a list of the things that I need at the grocery store? Probably not. Now, if I took that grocery list and next to each item on that grocery list, I wrote a poem about the lemons I was going to buy, or I wrote a short story about how my grandmother used to grow lemons in Florida, that would have inherent creativity in it, which would allow it to be protected by copyright. So let's talk about trademarks. Trademarks are a great subject because nearly every, if not every business has something that should be protected by a trademark. Whether you are producing a new line of sneakers or you are opening a nail salon, in all likelihood, you have something that can be protected by a trademark. And why is that? Trademarks identify the source of your goods or services. So if you are producing sneakers, those are goods. If you are providing nail services, you are offering manicures, pedicures, you are offering services. So your trademark is going to be an identifier of the source of the goods and services that you are offering in commerce. It also allows you to distinguish your goods and services from the services of another party. And the benefit of trademarks are twofold. They're a benefit to the trademark owner because, again, you want to allow people to know that this product or service is coming from you. You want people to select your product or service over the product or services of others. So think about when you go to the grocery store. Think about going down the cereal aisle. We have lots of choices in the breakfast food area, but there's the Corn Flakes, Frosted Flakes. Which one do you choose? There's Fruity Pebbles, there's all types of cereals. By having those trademark names, and that trademark name may be Kellogg, but it may also be Frosted Flakes. There can be multiple trademarks layered on one another, again, to identify the source of goods and services. So by using a word, a slogan, a symbol, a design, or a combination of these, you are providing information to the consumer. Now, from the consumer's perspective, trademarks are incredibly valuable because they, again, allow you to build a brand identity and appreciation of what you like. And it allows you to know the quality in a product because you come to know and appreciate that particular brand, and it gives you that opportunity to be a repeat buyer. So some examples of trademarks, again, they can be words, they can be images, they can be a combination thereof. Starbucks. I think for most of us, if we heard the name Starbucks, we'd immediately think of a coffee chain. It's a store that provides coffee services, that provides coffee-related products. If we saw the mermaid in the circle, green and white, we would probably all also recognize that it is Starbucks. Another example, Nike and Target. Both of those, I think, are common to many of us. There are also some things called non-traditional marks, and these can also serve as an indicator of the source of goods and services. If somebody says to you, what can Brown do for you? If you've ever seen or heard their commercials and seen their delivery trucks and their delivery drivers who wear this classic brown uniform and drive these brown trucks, you immediately know that it's UPS and that it's not FedEx. The green of John Deere, the robin's egg blue of Tiffany. There are also non-traditional marks that are scents. You don't see too many of these, but there's a handful of them. One of my favorite being the scent of Play-Doh. For any of us who've ever taken the cap off a can of Play-Doh, we know that there is, Play-Doh in that jar, and it's a creative clay that's used by children and adults to build and mold all types of things. There are also sound marks, the giggle of the Pillsbury Doughboy, the NBC chimes, for example. So when our trademark examiners, and there's approximately 600 of them, when they receive your trademark application, they are going to analyze your application and compare it against trademarks that are already known and already registered. And they will look for both state trademarks and federal trademarks, and they will also look across to see where anyone is using something in the manner of a trademark, because there's also something called a common law trademark. Now, the U.S. Patent and Trademark Office, we federally register trademarks, and you know something is a federally registered trademark if there is the circle with the R inside. That indicates that they have received a federally registered trademark from the USPTO. The trademark examiner is going to identify and have the thought process and the analysis is, are the marks confusingly similar? They are going to look at the mark you're applying for and marks that exist already and determine if there is any similarity that would cause confusion for a consumer. Do they look alike, sound alike, have similar meanings, create similar commercial impressions? And again, they're going to look across the spectrum and see, would there be a likelihood of confusion for the consuming public? Now, I'll give you an example. Delta Airlines, Delta Faucets. Those words are the same. They sound alike. In print, they would look alike. Now, Delta Faucets and Delta Airlines have very different graphics, but if one were to hear the term or to see it written textually, you would say there could be a confusion. They look alike, they sound alike. However, we then have to look at the next step of the analysis. Are the goods or services related? Are they encountered in the same channels of trade? So this is really a two-prong analysis when analyzing trademarks. Are the marks confusingly similar, and are the goods or services related? Going back to Delta, we know that Delta Airlines provides air services. They will fly you from state to state and country to country. However, Delta faucets are something you're going to find in your Home Depot. For anyone who's done a bathroom renovation or bathroom repair, you may have purchased a Delta faucet. Were you ever confused when standing in the aisle of the Home Depot that, wow, who knew that Delta Airlines was now selling faucets? No. This goods and services are not related. They are not in the same channels of trade. And thus we have the ability to issue those two trademarks again, because there is not the likelihood of confusion. So now we're going to get into patents. And this is where I am going to specifically call out my colleague Edgar to jump in. Patents are the right to exclude, and you would see this in the language of the Constitution, the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention for a limited term. Remember that chart we saw, that chart that was just chock full of information? That chart showed that that limited term for utility patents was 20 years from the date of filing, design patents 15 years from the date of issuance, and plant patents 20 years from the date of filing. They are territorial. As I said right up front, there are no worldwide patents. I don't anticipate seeing that in my lifetime, although never say never. A US patent provides protection only in the United States, and that's true of any patent that is issued by any country. It only provides protection in that particular country. And this is important because you need to consider, as an inventor who hopes to commercialize an invention, where do you need to patent? And that's a tough decision because it becomes a financial decision as well. Anecdotally, people say that you should patent in those countries where your competitors are, where you plan to manufacture, where you plan to sell. But that's just anecdotal. It's a good conversation to have with a patent attorney. So we've already talked a little bit about these types of patents, utility design and plant, so we won't go into this any more specifically here at this moment. But let's talk about the anatomy of a patent. And Edgar, do you want to jump in? Why is it important that we have all of these aspects to a patent, and why, what are the parts of a patent, and why is it important?
Absolutely. Thank you, Elizabeth. Yes, absolutely. So a patent essentially, like Elizabeth presented earlier, is the right to exclude others from different aspects such as selling and so on. But the going a little bit deeper into what is essentially the elements of a patent, we have several elements, such as, for example, abstract, the written description, the drawings, the claims. But most importantly is just that all these elements will give you essentially the way how you're looking for something. Let's say you're interested in a new device that is making or improving another invention. So typically in the areas or in the parts of a patent, such as the abstract, you get to observe a brief summary of what the invention is all about. In terms of a written description, it's a detailed information that goes from a neat description of the different elements, such as figures and all the components that it could be from a device. It could be a process, so composition of matter and so on. But and now when we're talking about drawings, we need to see in a patent how I would say, graphically speaking, what is it that you're trying to get protection for. And of course, like it's called, the name of the game is the claims, and this is the most important part of a patent. If the claims, it could be that the claims are essentially the metes and bounds of an idea, of an invention. So where are the limits? Where is the perimeter of intellectual, I would say, intellectual property protection? Where is it that your invention is different from your competitor? So these elements may sound at first sight perhaps a little simple, but they're really complex and essentially distinguish every single invention from one another. I would say from experience that when I started examining, for me, I started like any other person that may not be, I would say, would be uninitiated to the patent intellectual property field. I would say, okay, I'm gonna read first the written description, and then you spend perhaps a lot of time reading 20, 30 pages. But most importantly is I would say is the claims and how the claims get interpretation. So most reasonable interpretation out of the claims. But just to make it more, I would say more specific, claims, drawings, abstract, written description, all important elements of a patent. Like for example, you see in this figure, we have other elements such as the issue date and the invention, the title of the invention, the filing date. Filing date is really important, because this is going to be essentially how you're going to be able to enforce your intellectual property, your patent, based on the date of the file and based on the filing date. I think, you know, it's at first sight you might have heard the word patent. I have a patent, but sometimes, like Elizabeth mentioned at the beginning of the presentation, that, for example, in this program, Shark Tank, they were asked, do you have intellectual property? And they might say, yes, I do. I have a patent pending application a couple of years ago. But, you know, patent pending doesn't mean that they have already been awarded a patent. It's just that it may be a non-provisional, a provisional application, which is something that is oftentimes filed before a non-provisional. But these are kind of I would say the vocabulary or the language that you might, as you go deeper, you should be able to get more ideas. But I think that's it's really important. In addition of the first page of the patent, you get to see what were the ideas or the prior art is what they call it, how these different references or inventions preceded the now awarded patent. And based on that, so typically a patent examiner is able to see what's been in the past, how technology has advanced and has been applied or correlates to what you're trying to get protection for.
Edgar, that was fantastic. Thank you. I know I learned something today. You know, to talk about patents at a little bit greater depth, and again, I know this is really just an introductory conversation today. There's several questions that are going to be asked with respect to your application. And one of those is, in fact, is your idea eligible for protection? Because, and I'm going to jump ahead to a slide here, because I want to talk about what is not patentable. You cannot patent a mere idea. Now, does this mean you have to have a prototype? The answer is no, you don't have to have a prototype, but you have to have something that is able to be developed into a new, non-obvious, and useful machine, manufacture, process, or composition of matter that can actually accomplish the task. The difference here is this, and I'll give you a simple example. I have an idea, and my idea is I'd love to create a time machine because I'd love to go back in time and meet people like Abraham Lincoln and Harriet Tubman. Now, do I have an invention? No, I have an idea, but you cannot patent an idea because with my idea, I have no way or no clear path to actually producing that can actually accomplish the task. You also cannot patent natural phenomenon or abstract ideas. Now, to jump back, I want to just touch on this very quickly because I know we're quickly coming up on the end of our hour and we want to leave time for questions. Hurdles to patenting, and that maybe sounds too negative. The things that examiners like Edgar are going to look at when examining your application is your invention new? Is it novel, not previously known before in the prior art? And prior art, as Edgar pointed out on that front face of that patent, is patents, published patent applications, and non-patent literature that is pertinent to the patentability of your invention. It is something that is published and publicly available. So when we say novel, was your invention ever published and publicly available or known to the public? We also are going to look at whether your invention is an obvious variation over an existing invention. And we're also going to analyze the third prong, does it have utility? Meaning, does it function as intended? Does it have a purpose? So as Edgar mentioned, there is something called a provisional patent application. It is not something which results in a US patent, but it can be part of your process and something that we're going to talk about in a later part of our 7-part series. So definitely tune in because a provisional application can be a great introduction to the patent system. And as Edgar said, it does let you use that term patent pending. However, it's not something that's enforceable until that US patent issues. As this slide suggests, there is the difference between the provisional patent application and the non-provisional patent application. These are applications we're discussing here and not actual patents. The non-provisional patent application that you file with the USPTO is what can become a patent. The provisional, again, is a great tool. It's a 1-year placeholder to file with the office to get something on record and to start building the foundation for your non-provisional. However, it's not required. It's a low cost of entry, a low barrier of entry, and something that people use regularly. But I look forward to our discussing that further in, again, one of the next parts of our series. This is a great spot to have Edgar jump in again, and this is because when you file your US patent application, you are going to begin a communication and collaboration with the US Patent and Trademark Office. And it's one where we hope you're going to arrive at a US patent, but that doesn't always happen. But it is a process, and it's a process where we work with you to try and determine if you have a patentable invention. Edgar, what would you recommend that people know about the patent prosecution process?
Yes, thank you, Elizabeth. So in terms of the patent prosecution process, I would say it's, first of all, it's a process that every applicant needs to go through. So first of all, the fact that you have created any process, any composition of matter or any device doesn't entitle you at that very moment that you should be worth of being awarded a patent. So then it needs to go through a process in which we as examiners need to study your patent application. We need to see what is the prior art, like the references that have been applied. Let's say it could be that it's a continuation of another application, but essentially speaking, in this, when I saw this diagram, I really liked it at first sight, because I said, wow, that essentially really reflects what we do, and it's a kind of a feed forward or a feedback type of process. It could be two ways. It could be that let's say you're not there's some issues and you say, no, my idea really deserves a patent, and I'm not accepting that this should be going to. It goes from first of all, your patent non-provisional application gets examined, gets to the examiner, gets docketed to the examiner. The examiner starts reading the application, the claims, all these elements that you saw at the beginning, abstract, and so on. But most importantly, the examiner determines, okay, so what is this? What is the inventive concept of this application? What are the metes and bounds? Is it patentable? Is it not patentable? Is it something like Elizabeth said? You cannot patent a time machine. Is it like by the same token, you cannot patent a formula, but you can patent the utility of the formula as applied. So, but in this diagram, definitely if we determine that we need to see, we're able to find a reference that is able to read on your claims, on the subject matter of your claims, examiner will decide to provide a rejection, a non-final rejection, a first appraisal of your patent application in the view of examination, and based on that, okay, this is going to be called a non-final rejection, where you also will be finding different observations with respect to what's been missing on a figure, what's been missing on the claims are incomplete. There should be some issues with respect to the statutes, such as, for example, what can you patent, what cannot be patented, and several of the ideas like novelty, non-obviousness, double patenting. Let's say you belong to a company, you went or moved to a different company, and it happened that now you're contributing to the same technology, and there's some conflict. So there are some ideas, some different back and forth, but there's a way how applicant should be able to assess what's being provided as a non-patent, non-final rejection, and provide amendments, provide different contributions to the claims. Okay, well, I technically see that the prior art that the examiner has been able to find is reading on this particular element. Let me see how I can amend that. Let me have an interview with the examiner. So as you see, there's a full interaction from beginning to end until a patent is awarded. But it could, as you see here, it could be that prior art is so strong and is reading on your application that you seem to realize, wow, I haven't invented this, but let me see how I can make an improvement of what's been out there. So there are many ways, many I would say points of view how applicants may not have the same point of view as the examiner. So and it's a back and forth. You could also appeal it if you're finding that no, I'm pretty much sure that this is patentable. You may appeal it. It could go into abandonment if you decide not to continue. But if at the end there's a good quality patent that this is a product, it could be a device, could be a process that is really novel, non-obvious, definitely without any hesitation, you will be awarded a patent, provided all these different constraints and all these elements of examination are satisfied. But
Edgar, you make a really good point with respect to when the process this process allows us to produce good quality patents. And that is our bottom line objective. The U.S. Patent and Trademark Office wants the same thing that our applicants want. We want to issue them a U.S. patent that they can take to the bank and not to the courthouse. So by having this back and forth process, we do arrive ultimately at what is patentable subject matter. And thank you for walking us through that collaborative process, because you're right. There's so many steps along the way, but it's not one to be fearful of. I do think this might be a good place in our conversation to mention that you are not required by law to use a patent attorney or a patent agent. However, it is strongly recommended because it is a complex process. Just like buying a piece of real property, the last time you perhaps bought a house or a car, you had to sign on the dotted line a number of times. Well, seeking a U.S. patent or any form of intellectual property really has a certain inherent level of complexity in it. Patents especially. You are receiving a right from the federal government. So there is a certain inherent level of complexity in the process itself and in disclosing your invention with such specificity that others can make and use it.
Yes, that is true. And the responsibility behind that, because you're kind of the owner of this intangible that needs to be enforced. Certainly. And it needs to be handled with a lot of responsibility.
That's very well said, Edgar, because you're right. The patent owner is the one who the responsibility of enforcing it falls to. Once the U.S. Patent and Trademark Office issues that right, it then becomes the property of the rights holder, of the patent owner, to then enforce. You know, too frequently we hear somebody say, oh, I have a patent, it's my ticket to $1 million. Well, that's a great and a fantastic way to look at it. However, the patent is just that first step. There's so many steps to be taken after that patent, but the patent is certainly a good first step. I know we're just about out of time. We're at the running close to the end of our hour. Our next presentation in the series is going to focus solely on USPTO resources. So I'm not really going to get into these today, but we have included them in your slide set so that you do have them. You can start taking a look at them and familiarize yourself with some of these resources. Let me just say, like the SBTDC there in Puerto Rico, which has incredible resources for inventors, innovators, and entrepreneurs, the USPTO does as well. And these resources, many of them are my favorite four-letter word. They are F-R-E-E, free. And we're going to be excited to share these with you in the next session. With that, I think I'm going to go ahead and perhaps stop sharing my screen. I'm assuming we have some questions to hit. If that's right, I'll stop sharing my screen and we will jump into the questions. If there aren't any questions at this time, we can touch on some of these resources. Valentina, what do you recommend?
Well, Elizabeth, we do not have any questions at this point.
Okay.
So if you just want to go ahead.
Okay, we can certainly do that, and we'll encourage people to start putting their questions in the chat right now then. So we will go ahead and just start with a basic introduction to some of these resources, again, knowing that we're also going to hit these in our next collaborative presentation. One of the first things I always recommend to individuals who are getting their feet wet in intellectual property and thinking about patents and trademarks is to visit our website. Visit us at www.uspto.gov. And when you go there, what you're going to find is a huge amount of information. So I always strongly recommend that people start, I'm just getting that out of the way, with the Learning and Resources pull-down tab, because that Learning and Resources pull-down tab on the top toolbar is a great entrance into education and information for inventors, entrepreneurs, startups, kids, and teachers. It kind of really puts in one place, kind of a great place to get started. We also always have a Journey of Innovation featured there, where we talk about great inventors, innovators, entrepreneurs that are doing things with their intellectual property. This particular story here is about 3 lovely women who were inducted into the National Inventors Hall of Fame for inventing the first sports bra, known originally as the jog bra. These 3 women are credited with inventing the first jog bra. I also, along our bottom toolbar there, recommend that you find the direct resources in your geographic location. So if you visit USPTO in your region, what you're going to come up with is a map of the US. You can select Puerto Rico, and there you will find resources, and we'll talk a little bit about those here in just a second. So as I mentioned, Edgar and myself are located at the Alexandria headquarters, but we do have regional offices in Detroit, Denver, Dallas, and San Jose. Should you ever want to meet us in person once our offices reopen? Again, this specifically calls out my office, which is the Eastern Regional Outreach Office, and we are located there in the Alexandria headquarters. For those of you who are visual learners and enjoy going to a webinar class, class that has video and content, we do have a YouTube USPTO library that has a wide range of materials. Some are pre-recorded sessions from conferences or programs that we've held. Some are materials that were created solely for the YouTube channel. So I encourage you to visit that site. We also have something called USPTO subscriptions, and you can sign up to receive any and all of these depending upon your interest. These are free alerts that dump into your email box when we have something to say. We promise to not spam you, and we promise to not give away your email address to others. But this does allow you to have current notices of upcoming programs, of rule changes, of things that are going on at the U.S. Patent and Trademark Office. We also have a very robust events page. And if you recall, when I indicated that you should start at the Learning and Resources pull-down tab, that's where you can find our events page. And at any given time, any day of the week, Monday through Friday, we have multiple programs going on. This month, we have over 25 programs going on a variety of topics. For example, learn how to draft patent claims, but we also have a World IP Day celebration taking place on April 26th. We have a number of programs regarding patents, trademarks, copyrights, trade secrets, how to protect your intellectual property in China, just to name a few. We also have a page, and again, this is a great one to get started on. If you type into our search box the term startup, it's going to take you to this page where we have culled into one location, a one-stop shop for startups. Patents for startups, trademarks for startups, startup assistance, and again, a link to our current events page. Our Inventors Assistance Center, or our IAC, is available and staffed Monday through Friday, 8:30 to 8. And these folks are retired former supervisory patent examiners and primary examiners, individuals like Edgar who love to take your call, and no question is off the table. If it relates to filing or perhaps a patent application that's already in prosecution, these individuals love to give you help and love to talk to you. So they welcome your calls Monday through Friday. We similarly have a Trademark Assistance Center for those of you who are seeking assistance in either filing or prosecuting a trademark. Again, this team is available 8:30 to 8 and welcomes your calls regarding trademarks. We also have a patent pro bono program. And again, we're going to talk about all of these resources in greater depth in our USPTO resources conversation. But it's important to know, and we want to bring to everyone's attention, that as a result of the America Invents Act of 2011, Congress urged the U.S. Patent and Trademark Office to collaborate with legal associations across the nation to stand up pro bono programs to ensure that under-resourced inventors did not leave an invention on the kitchen table or on the garage workbench because they were financially under-resourced and unable to bring it forward. For those of you in Puerto Rico, the Federal Circuit Bar Association, which also assists inventors in Washington, D.C., Maryland, and Virginia, also serves the Puerto Rico community. Related to the Patent Pro Bono program, and again, you can see that these programs are available across the nation. We also have a law school clinic program, and these programs, and there is one at the law school clinic. There is a law school clinic at the University of Puerto Rico Law School. At these law school clinics, you can receive free or reduced cost legal services through a student working under the supervision of a registered patent attorney and professor. So again, for those of you who are feeling daunted by this process and thinking that perhaps you are not in a financial position to take it on, there are resources available to help you. I see we are at the end of our hour, so I think there's only let's hit the PTRCs and then we'll wrap it up, because I think we're almost at the end of our slides and certainly at the end of our time. There is something called Patent and Trademark Resource Centers, and they are libraries, publicly available libraries across the nation where there is one or multiple librarians who is trained in patent and trademark searching. And in fact, we have two in Puerto Rico. We have one at the Learning Resource Center at Bayamon campus of the University of Puerto Rico. And we also have one at the General Library at the Mayaguez campus at the University of Puerto Rico. And again, these librarians there oftentimes offer classes in intellectual property, and they also can assist you as an individual with setting up a high quality patent or trademark search. So with that, I am going to stop screen sharing. I think I've done that, correct? Or are we still seeing it?
Yes,
Okay, perfect.
Yeah, at the end of our hour, so my apologies for the technical challenge we had at the beginning of the presentation, but thanks to Elizabeth and Edgar for this excellent presentation. This webinar will be available in our website, prsbtdc.org. So for our participants, thanks for listening. Hope you have enjoyed the webinar, and please visit our webpage for information on future trainings. There were some questions that came at the end, so I will try to get back to those participants individually. and answer those questions. Well, thanks for your collaboration and have a nice day.
Thank you. Thank you, Valentina, and we look forward to the next installment in our series. Thank you to all of you who attended today.
Thank you.
Goodbye.
Goodbye.
Oh my goodness.